But what really struck me are the parallels that still exist. The jury hears evidence of 2 murders, but Ruth is only charged with 1. How fair is that?
Even if they can show that she did that, it doesn't mean she killed them. That is a separate, different crime. She was a witness, and she was terrible. She was all over the place. She was screaming. She tried to run out of the courtroom.
This is a case that people could study for years.
All right, so we're back for part 2 of The Trunk Murderess, Winnie Ruth Judd. So we first talked, if you haven't seen the first episode, I'd encourage you to go back to that one, talked about the facts, what came out in trial as far as what happened. We also went beyond trial facts and talked about some of the other facts that we're aware of or that have been rumored. And so it was helpful to kind of have that background. We did dive a little bit into the legal side of it, but today our focus is going to be on really her legal challenges to the Court of Appeals after the conviction. It's interesting just to kind of compare it to today's law, but also kind of talk through the legal issues a little bit.
It was actually to the Arizona Supreme Court. Today, if someone is sentenced to death, we should clarify this. If you go to trial on a felony case and you're convicted, you have an absolute right to appeal to the Arizona Court of Appeals, which is the next highest court. However, if your sentence is a death sentence, you automatically bypass the Arizona Court of Appeals and your case is heard by the Arizona Supreme Court.
And it's an automatic appeal.
Automatic appeal, and the Supreme Court will review your death sentence and any other issues that you raise. I can't say with any certainty that that is the reason that her case was appealed to the Supreme Court. It may be for some other reason. But today, if this were to happen today and Ruth were sentenced to death, the Supreme Court would review her sentence. In any event, her case was reviewed by the Arizona Supreme Court. And at the end of the last episode, we gave a little bit of context. I mean, you're talking about now an opinion that is nearly 100 years old. At a time when Arizona was a little bit more Wild West. It was a newer state. This was, 20 years into statehood by the time it reached the Court of Appeals, or the Supreme Court, excuse me. I know I'm going to make that error 9 times in the episode, so, somebody can count that. But by the Supreme Court, the Arizona Supreme Court. And so times were different. We talked a little bit about how the law back then was more common law, more case judge-made law through cases and judicial opinions as opposed to statutory law. But what really struck me are the parallels that still exist. And you commented on that, and I appreciate that the laws that the court applied here in many ways are identical to the laws that still apply. And so even though things have been passed through various rules and statutes by the legislature or court-made rules that are codified in the rules of procedure, the rules of evidence, those same rules were applicable 100 years ago.
I was stunned at a couple of the things where it literally laid out the same exceptions and elements that we would see today. And it's also interesting to think about, that's how law gets made,
Sure.
I guess, right? Like, as you say, here's the judicial opinions over time. Let's accept that rule. Now legislators, now that we're a little bit more of a grown-up state, let's make a statute or a law where it's written in so that there is an inconsistency that happens amongst different judges, and so that they have to follow that codified, you called it, making it a code law.
Well, and I think it also represents or makes clear the idea that law does not change quickly, right? It's not like once the legislature decides to make something into a statute that they're going to go and rewrite everything in the past. No, what they do is they'll write into statutes things that judges were already doing. And change in the law always comes incrementally. There's rarely sweeping change. Now, sometimes those things do happen, and we've experienced some of those things depending on the area of law that you're talking about. Here and there, you'll get sweeping changes. But more than anything, it's incremental changes. And so it is really interesting to look back and say, hey, that's kind of the same thing that we do today.
Yep.
Right?
I was surprised by that. I'm picturing this Wild West tombstone town, right? But it was a really rather sophisticated, opinion.
Yeah, and so Ruth, on appeal, raised a number of issues. I think we could put them into about 4 or 5 categories. The first of those categories that the court dealt with was this question of insanity. And we've talked in the past about jury instructions. Now remember, jury instructions are the rules of the road that the jurors have to apply when they decide what the facts are in a given case. Today, in order to show that someone is insane, defense bears the burden of showing that the accused, the defendant, suffers from a mental disease or defect that prevents them from understanding right and wrong. And guess what? In 1931, it's basically the same standard.
Yeah, pretty much the same.
Yeah, and so what Ruth took issue with is that instruction saying, no, that shouldn't be the test for insanity. She wanted the court to apply a different test, which is what they call irresistible impulse test, which other states at the time applied that irresistible impulse test, which is basically that you suffer from some sort of mental disease or defect that forced you to engage in whatever conduct in a way that you couldn't stop yourself.
Even though you recognize the wrongfulness of the act.
Well,
or even if.
No, I think the wrongfulness of the act is still in play. But it's this mental defect that forces you to engage in certain behavior.
Yeah, and I think that was the problem, right, is that the court found that to be confusing to a jury. And I think this is such a good example, again, right, of we talked about jury instructions. I mean, that's commonly an attack for appeals. And one of the things that you run into is I know this is true, that you could take the same set of facts, right, put them next to each other. You apply it to one jury instruction, you get a not guilty. You apply it to a different jury instruction, you get a guilty. And so it's such an important piece if you can change that jury instruction to, and we're always fighting for that from the defense too, is getting the most favorable instruction that we can get.
Yeah, and I should correct myself. You were right. Okay, I'll read exactly from the opinion. It says, notwithstanding that the fact that one accused of the crime is able to comprehend the nature and quality of his act and to know that it is wrong, nevertheless, if he is forced to do it by an impulse which he is unable to control because of an actual disease of the mind, he will be excused.
And it actually took issue with that, with their analysis of this.
Okay.
In this case, because Ruth's attorney basically said, should we just read what they wanted read? So basically what you can do is you can propose a jury instruction.
Right.
And they did that, and the judge turned it down because he said he thought it was too close to being, or he thought it was the other standard, which is that you can appreciate the difference between right and wrong, but you can't stop yourself because of an irresistible impulse. But that's not, in my opinion, what their instruction said. It said the term insanity, so this is what they wanted read to the jury. The term insanity, as used in these instructions, means such a perverted and deranged condition of the mental and moral faculties as to render a person incapable of distinguishing between right and wrong. Or, unconsciously at the time of the nature and quality of the act she is charged with having committed, and where, though conscious of it and able to distinguish between right and wrong, yet her will, by which I mean the governing power of her mind, has been so completely destroyed by insanity that her actions are not subject to it, but are beyond her control.
But that to me then is a hybrid. They want it both ways. They want to say, look, she can't understand right and wrong, or alternatively, can't control herself.
Right. I think there should have been an instruction in the middle, because the instruction that was used was incredibly.
If the law at the time, though, that was being applied in Arizona courts was you can't appreciate the wrongfulness of your conduct, injecting the idea of the irresistible impulse is against the standards in Arizona. So
should have taken that piece out, for sure.
But that's what they wanted, and that's why the trial court says no. we're not going to move on and allow this irresistible impulse test to come in because that's not what Arizona law allows for traditionally. Only a few, limited number of jurisdictions even allow that discussion. We're not going to allow it. And so I appreciate the creativity of the defense lawyers. They're saying, hey, Judge, other jurisdictions allow this irresistible impulse test. We want this court to apply it. And that is, to a certain degree, how law changes, is
Right.
by the application of law to new circumstances. It was just here the trial court held the line and said, no, it's you understand or you don't understand right from wrong because of a mental disease and defect. And then the Arizona Supreme Court says, yeah, that's what the law is in Arizona. We don't do this irresistible impulse test.
Yeah. What I didn't like about the instruction that they used, I don't want to get too deep into other things, but we talked in another episode about presumptions, right? And we talked about burden of proof, right? We talked about self-defense cases where they had to prove the defense or they had to prove the lack of the defense. The wording of the instruction that was used was incredibly confusing. The presumption of law is that every person charged with a crime is sane. I don't like that. Right? I mean, I get it. It's like you got to raise some defense onto it first. But anyways, the presumption of law is that every person charged with a crime is sane. And the presumption, therefore, is that the defendant was sane when he committed the act. If a person would avoid the consequences of his act on the ground of his inability to perceive and know such an act to be wrong, it is incumbent upon him at least to raise a doubt in the minds of the jury as to his sanity. If the jury believed from the evidence the defendant was sane, the law implies deliberation and premeditation from the circumstances of the killing. That's another thing that I thought goes way beyond it. Now it's talking about first degree just because you're not insane, okay? The degree of the crime is not dependent upon defendant's intelligence or lack of intelligence, his power to reason or not reason. If he knew the nature and quality of his act and that it was wrong, he is amenable to punishment, therefore, to the same extent as if he were one whose sanity is not questioned. The law does not discriminate between degrees of intelligence in fixing this penalty.
Well, there's no doubt that that is incredibly confusing, right? And even taking into account, some of the changes in language over time, that is a really complex instruction. I think what it's doing, of course, is saying the presumption is that you're sane, and it's on the defense, it's an affirmative defense to show that you are not sane or that you suffer from a disease of the mind, that you don't understand the wrongfulness of your conduct. And they're not going to measure, your degree of intelligence and so forth. But really, it's on the defense to prove it. Now, at this trial, the defense did raise that question of sanity or insanity. They put on an expert. His name was Dr. Stevens. And one of the issues, this kind of flows into the next issue that the court dealt with, was the prosecutor's cross-examination of this expert. I love how the court describes this. This exchange between the prosecutor and the defense expert was what the court called a spirited dialogue, right? These two were probably just going after each other, right? And that's not uncommon. It is common for prosecutors and defense experts to really tangle with one another. And where the defense took issue with, the way the court did things was the prosecutor asked a question because this expert that they had called, Dr. George W. Stevens, was the superintendent of the Arizona Hospital for the Insane. The prosecutor on cross-examination asked him whether or not he'd ever taken an examination as to his qualifications to hold the position of superintendent of the state hospital, questioning his qualifications, basically, which you can do
all the time,
and you should do.
I mean, that is like 101 for experts.
Absolutely. Yeah. And Ruth, through her attorney on appeal, said that he shouldn't have been able to ask that question, which you and I can sit here and say, of course you're going to ask that question. But I think what they thought was sort of rude and demeaning of this person to even question his qualifications. How did you even get your job anyway? Kind of thing. But the court says, no, that's fine. And so, this issue of insanity is raised. It's not successful because the jury does find her guilty of the crime and sentences her to murder.
To death.
To death. The issue, though, like you said in the first episode, later, she is found to be insane. I'm still blown away by how that happened.
Yeah, and let's go back there, right?
Yeah.
Because if you're now found insane, and your defense was, I was insane, but that wasn't good enough to find you not guilty. It is a little bit of a different standard potentially, is to say I'm now not able to help in my defense because I'm not, not able to understand the nature of the proceedings. That's how it kind of works a lot of times now too. But this defense in trial is about your mental state at the time of the murder.
So at the time of the murders. And, obviously it didn't work, and then later it did, which I guess is what has you and me a little bit baffled in terms of how that sentence can be undone. But it was.
But like from outside, not from within, the Court of Appeals and the Supreme Court. It was done through like a side door.
Through the prison system. Yeah.
Yeah, and that's not available to us now. At least I'm going to look into it.
I have no idea. I've never heard of it happening. I'm not a mental health expert. I've certainly handled insanity cases, and I've handled other, mental health defenses and things, but that procedure is unknown to me. Okay.
Yeah, I don't think it's a rule anymore. That apparently that was a rule that the sheriff could raise.
Does the final inspection?
Yeah, talk about not being a mental health expert.
Right.
But there you go.
So one thing that was really interesting about Ruth's trial is that, remember, there were 2 homicides, 2 deaths. They were, again, Agnes Ann Leroy, and then the other woman, Sammy, whose name was Helvig Samuelson. Well, Ruth went to trial only in the death of Agnes Ann Leroy. That murder is the murder that was in front of the jury. However, the jury heard evidence of that other killing.
And this should sound familiar to our
Think
listeners.
about these things, right? You have 2 trunks, 2 bodies, offenses that are, what they say, are inextricably intertwined, right? How do you talk about one without talking about the other? Okay. So we call that other acts evidence. So the jury heard about that second murder, even though she wasn't charged with it. Back in 1931, it was not called 404B evidence, but we've now discussed 404B at least twice.
Which just seems to keep
rearing its head, and we keep saying that. So think about that for a moment. The jury hears evidence of 2 murders, but Ruth is only charged with 1. How fair is that?
Yeah, it's always fraught. To me, it's dangerous ground. In fact, again, this is one of those things that where we were talking about specifically where the rule is so similar to the analysis that the court did here in this case. In fact, even saying that it's presumed that evidence of other acts is inadmissible and irrelevant.
That's right. And the court says a number of times, gentlemen, at this time, the court instructs you that the defendant in this case is charged with the murder of Agnes Ann Leroy. She is not charged with the killing of Hedvig Samuelson or any other person. You are further instructed, gentlemen, that some evidence has been admitted and permitted to go to you in which the state attempts to show the killing of another person, to wit, one Hedvig Samuelson. Okay, so the jury is told, hey, she's charged with this murder, but you've obviously heard evidence of the second murder. And the question is why? Why did they allow that to happen? And if we look at the current rule, 404B, one of the reasons that you can present other acts evidence is to prove motive, intent, common scheme or plan, or other factors, or identity. And what does the court say? In his instruction, it says, you are therefore instructed, gentlemen, that any evidence tending to show the killing of Hedvig Samuelson, if you do so consider it, was introduced by the state for the purpose of proving intent, motive, common scheme or plan, or identity of the defendant. So that is a rule, 404B, that has its roots in common law, that clearly, that rule is in play today, and it sounds almost identical.
And we should reiterate our problems with this, with this evidence that comes in, right? Because again, it's maybe the language of the day, that they're used to being a little more wordy than we are now, but basically says, and the court further instructs you, gentlemen, that you may consider such evidence if you see fit for those purposes or any one of those purposes, and for no other purposes. And that's where I always struggle, right? Is you get to use this evidence just for, these purposes about this one murder, but you don't get to use it to say that she's more likely to have committed the murder she's on trial for. how do people separate that out? They just really...
I don't know. And I still struggle, I guess with this case, I'm struggling with if she murders Leroy and the other evidence of Samuelson is presented, in your mind, either the defense or prosecutor had, I don't care, how does the other murder prove intent, motive, common scheme, or plan or identity? I mean, I guess they loosely can fall into the idea of common scheme or plan. I mean, we did talk about how these two women were kind of seeing the same guy, and perhaps her motive is jealousy and other things. I mean, we can spend some time thinking about those. How it proves identity. I mean, these murders weren't, apparently they were committed at the same time by the same gun, right? So I guess as we discuss it, yeah, those things are present. But to your point, how does the jury separate those things from, gosh, this is a brutal woman, she needs to burn?
They can't.
They can't.
That's the answer. Is that they juries take all of the evidence and decide whether they think it helps them to decide whether this person is guilty or not. Not just, of this crime, not to just say, okay, but I'm not going to use the fact that they have some evidence that she killed somebody else. I'm just going to use it to help me show that must have been her, right? Or that she had an opportunity or a motive to do that.
Yeah.
But I'm not going to hold it against her otherwise.
And it wasn't clear to me, maybe you know this, but it wasn't clear to me why she wasn't charged and tried at the same time with both murders.
I did see something on it, whether it's correct, I don't know. My understanding was that they severed the trials. We've talked about that before, where defense wants to sever the trials.
Agreed, but if you're going to allow the 404 evidence, what does severance matter?
That's what we talked about last time too, where it's like the defense wants to sever a lot of times, right? And say, because I don't want the jury to hear that there's all these other things because they're more likely to think I did the one, but then they get to use that other evidence anyway. And maybe you got to just take that gamble because you never know for sure whether that's coming in until the judge rules on it. But I think that a prosecutor might do it for a couple of reasons. Number one is they get two bites at the apple, right? They try one, they fail at convicting. Now they've got another defendant to bring in.
Yeah, and they can fix their mistakes and so forth. In this case, maybe the prosecutor does want two trials. That makes sense to me.
Yep.
Right? Because this is kind of a whodunit in that you don't necessarily know who pulled the trigger or, who chopped up the bodies and things. So,
and we talked about this last time too.
Yeah.
In another case, there's so much focus on chopping up the bodies and moving the bodies. And even if they can show that she did that, it doesn't mean she killed them. That is a separate, different crime.
Yeah, and I don't know that it was a crime. She wasn't charged with it. I mean, today it would be, right? I mean, that mutilation of a corpse, I think is what they call it in Arizona. But I don't believe it was a crime in 1931. It was just some good packing that she was doing.
Sometimes you had to do that with,
right.
Family members that died. I don't know. They're on the Old West, right?
Now I'm thinking of the Vacation movie, right? Where he's got the ant in the car.
Chase Fair.
I guess it is another chase.
Yeah. So I mean, that's interesting stuff to think through. Kind of that, I guess, decision making by the prosecutor back then.
But again, it shows you the power of 404 evidence, right? Other bad things that are done, the jury gets to hear those things, and it just muddies the character of the defendant, right? But to me, though, these murders are so closely connected that I don't see how you hear one without the other. It's just part of it.
I guess then I would think that it's dirty play then on the side of the prosecutor
to want two trials.
Yeah.
Yeah.
To want two trials because they know they're trying to get in the evidence of the other trial, the other murder on both cases.
Right. Well, speaking of jurors, we've talked a little bit about jurors. One of the things that they raised was juror misconduct. There was this fellow Kleinman who sat on the jury. They wanted him during jury selection to be excused because he was biased and prejudiced against Ruth from the moment he entered the jury box, and it was impossible for him to give her a fair trial. What can you say about that?
Yeah, so this is one of those ones, again, maybe it'd be fun to do some history on how this has changed on striking jurors.
Yeah.
When jury selection happened, when you and I first started, it was different than it is today.
100%.
So when we had felony trials, back then, it was more of a jury deselection process than a jury selection process. Sometimes people think that we're in there saying, I want that juror, and it doesn't never worked like that. We would just say, I think this juror is not good for us, right? Or first, though, we'd try to get them kicked out for cause if we didn't like them.
Right, and I guess that's a good point. So up until recently, lawyers had two different types of strikes. And when we say strike, we're saying get rid of this juror.
And this is Arizona.
This is Arizona.
Yeah.
So we had what's called strikes for cause. Strikes for cause. And anybody, our viewers may have sat in jury selection and wonder what's going on behind the scenes. Well, if it appears that a potential juror cannot be fair or impartial or has some close relationship to the case that it affects their ability to judge the case fairly, then they can be struck for cause. Think of a person, for instance, in a DUI case who says, well, my uncle was killed in a DUI crash. This one just hits too close to home. I can't sit on this case. I can't be fair. Well, you're going to be struck for cause.
Right. You don't have to, we'll talk about you don't have to use your other kind of strike.
Right. The other kind of strike is what they call a peremptory strike, which is now gone in Arizona. We don't get peremptory strikes. And what those are is strikes that aren't for cause, meaning things about the person, things that they may have said, or maybe their, career that they've chosen, or, some thing that they like or don't like. You can say, well, I don't like that person. I want them struck as one of my peremptory strikes. The only limitation on that is that you can't strike someone for, race, gender, or other protected reasons. Otherwise, the other side can challenge that through what they call a Batson challenge. But that whole system, because of the risk of unfair play by one side or the other in choosing jurors, not choosing jurors because of race or other factors, the courts have done away with strikes. So you can't have them.
And that's just a couple years.
Just a couple years, yeah.
And I don't know if other states have followed suit or done it as well. I haven't really heard.
I think it's the trend, but yeah.
And it's weird because I think in federal court still here in Arizona, you still have them. It's just not state court.
So in state court, we can't get rid of jurors just for our own sort of personal reasons. But back then, this guy Kleinman, he had said on a number of occasions that I think she's guilty, she needs to burn, whatever, or be hanged.
Well, the witnesses saying...
And witnesses testified to that. But then he also presented, or the state presented witnesses to the contrary. And so the judge had to make the call. And this is a good example. So many things that a judge has to decide, the higher court reviews on what they call an abuse of discretion, meaning did the trial court exercise reasonable judgment in the situation? And if they did, we're going to let that stand. And that's precisely what happened in this jury selection process.
Yeah, so this type of thing, they're not looking at, do we agree, or would we have done the same thing, that kind of low standard. It has to be obvious, right? It has to be kind of an abuse of discretion, like a really high level of...
Yeah, really no valid reason for doing whatever they did. And here, just despite this sort of contradictory statements about his ability to be fair or not fair, the court held a hearing. At the hearing, the juror affirmed their ability or his ability to be a fair juror, and he somehow made it onto that case. The other aspect that we've touched on this is that Ruth raises is this self-defense claim. She claimed that she did kill in self-defense, but she didn't testify. She did it through this letter, this drain letter that they presented,
that the
state presented, and then also this wound that was on her left hand, the gunshot wound, saying it must have been self-defense.
And it's funny because we just talked about that. I guess it was in the last episode, so I guess we could touch on it again. Is that is pretty hard and fast, right? If I've got a client and our defense is self-defense, it's almost assumed that they're going to have to testify. Even though in most cases we don't really want our client to testify if they don't have to, you got to establish enough for a jury to go on. And in this case, there were so few facts about the actual event itself. Now, she tried to claim that this letter was sufficient, right? The letter that they had presented with no objection, apparently, from the defense about this letter, which was kind of interesting. And maybe they were like, good, you're opening the door for my self-defense without me having to call her to the stand. I don't know. Maybe that was part of the strategy. But the court ultimately says, no, the facts in this letter do not establish, even because it's a low bar. I don't want to confuse people, but you don't have to have a perfect self-defense argument. You just have to raise enough to say, yeah, a jury could find that there was self-defense there.
Yeah, and we should clarify what Ruth wanted at trial was an instruction on self-defense.
Right.
And the court refused to give an instruction because the court says there is no basis to confirm or to order self-defense or to even believe that self-defense was viable. The court goes on to say each of these women was killed by a bullet wound to the head, the pistol just discharging the bullet, and in each instance being held in close contact to the head of the victim. One of the women had been wounded in the hand and breast by a bullet fired either before or after the firing of the fatal shot. 2 witnesses, remember at the beginning we talked about 2 witnesses hearing 3 shots fired at the apartment. Court says no evidence whatever of any struggle having taken place, no screams or outcries of any kind. 3 shots fired up a dark house at the dead of night, 2 women dead of gunshot wounds fired from the weapon held at close contact with their respective heads. No slightest evidence of self-defense on the part of the perpetrator of the deed. Nothing. 0 evidence of self-defense, according to the court.
Yeah,
and so they don't even get an instruction. So what that means is the jury doesn't even have the option of picking self-defense.
And I had issue with this.
Yeah.
As well. I think that, because as I was reading through this opinion, I'm saying, gosh, I'd love to read the letter. Like, is there enough in there? And it is in this opinion of what it is. And again, it's not a perfect defense. Like, if you were to lay it out and say, here's what you should say for self-defense, it's not perfect for that. But there's enough in there, I think. And it's not perfect evidence either. It's not direct evidence. It's not, she wrote it herself. It could be considered self-serving. But she wrote it on her own without a lawyer. Soon after the incident. I think there was enough that there was enough foundation for it to come in as evidence at all. They let the state bring it in. I just disagree with that characterization that there's no evidence whatsoever to as a basis just for the instruction. The judge even lays out the rule that says it's a very low amount of evidence that has to be presented. And once you do, then yes, you're entitled to instruction.
Had she given some element of evidence about self-defense, the court, it seemed, would be willing to give the instruction. But what the court is saying here is there's no evidence of self-defense, therefore no instruction. And really her only claim then would be insanity, which, despite the vigorous cross-examination of the doctor, or probably because of it, that doesn't fly either.
And I don't want to read through this whole thing. It's really long, but maybe we could link to it. We can kind of get the
text of the letter.
Text of the letter.
Sure, I think that'd be great.
They did kind of italicize some of it, though, of what the defense was focusing on. It says, we were in the kitchen just starting breakfast. She came in with my gun and said she would shoot me if I went hunting with his friend. I threw my hand over the mouth of the gun and grabbed the bread knife. She shot. I jumped on her with all my weight and knocked her down. She said she was going to kill me for introducing this, her initials are LM St. Joseph, to their men friends, and said before Sammy got the gun, Ruth, I could kill you for introducing that girl, and if you go hunting, I will tell them, and they won't think so darn nice anymore.
Yeah, the letter kind of rambles.
It is rambling.
But there is some discussion, at least some allegation by her that there was a struggle and there was, some act on Ruth's part to defend herself.
She's a doctor, darling. If I hadn't got the gun from Sammy, she would have shot me again.
That's right.
It was as much a battle as Germany and the U.S. I killed in defense.
Yeah, she claims I killed in defense in the letter.
It actually says I killed in defense.
Interesting. I mean, wouldn't it have been better then for her to testify at her trial?
Sure. There's also, I don't want to get too deep into everything, but a whole separate grand jury hearing where they tried to indict her boyfriend, right, separately. She was a witness, and she was terrible. She was all over the place. She was screaming. She tried to run out of the courtroom. And so I think that her lawyer made a judgment call that it wasn't going to help having her testify.
Yeah, and remember, kind of a similar circumstance with Fish. Fish testified in front of the grand jury. I understand here we're talking about a separate grand jury involving the boyfriend, but he didn't testify at trial, and it came back to bite him. And then here, she doesn't testify at trial either. Now, I realize we're talking about 2 wildly different sets of facts, and maybe she was mentally unstable. I don't know. I mean, by some accounts, she was. She had to have been, and which is the reason why she went to the state hospital. But Really a wild case.
Yeah.
Yeah, and an interesting case. I think this is a case that people could study for years. Not just the case, but the facts, the drama, the sensationalism leading up to it, and then all of the kind of the mystery and sensationalism that followed after. I mean, her escapes and all of that, kind of thing. The love triangle. That's what gathers all the attention. Is this sort of drama between the ladies, and then two of them end up dead.
It's easy to see why people got so kind of taken by this case, and that people continue to almost 100 years later. I did. As I'm reading through it, this is a case I'm going to continue to learn more about. And like I said, I even popped by the house today, maybe look for some other landmarks around Phoenix that are still there. It's just really interesting to look at a piece of history for Arizona. I know it's odd because it's about murder, and can never lose sight of that there were two innocent people, potentially. We don't know whether it was self-defense, but victims, right? In this case, who it's tragic that they passed away. We don't lose sight of that, definitely. But as far as kind of what we do, it's a fascinating just study to take a look at what happened in this case 95 years ago in our jurisdiction.
And I think the New Times wrote an article about this about 10, 11 years ago. And their comment was this: her case was as big in the early 1930s as O.J. Simpson's was in the mid-90s. Right? So think about that. I mean, it's that kind of attention-getting sort of case that nearly 100 years ago had everybody following it, right? Like we're all tracking the Bronco on the freeway, right? It was part of their history at the time, their modern day history. And so fascinating to take a look back.
And you just dropped another bomb there, right?
Yeah.
Like it continues. We got this letter. What was it, 2011?
Yeah, so if you want to do a little bit more research into this, in 1933, a couple of years later, apparently this letter came out. Let's see, the letter
to her lawyer.
The letter resurfaced. A letter that Ruth wrote in 1933 came to light later on, where she does in fact take accountability for the killings and sole responsibility for the killings. And according to her final lawyer, a guy by the name of Larry Debus, offers probably the most consistent version of the facts in terms of what actually happened and how the evidence played out. And so her story in the end was, it was me. Yeah, I did it. I killed them both.
But you have other people, right?
Yeah.
Like, I can't remember this woman, I think in the New Times, who did a really deep dive, who actually got to know Ruth really well. After she was released, they would have lunch together. They would talk and everything. And she is adamant that this letter was
a forgery?
Well, no, a real letter, but that was written to her lawyer to try to kind of please him on what they were trying to do. It was not a legitimate thing. So round and round we go.
Yeah, because what do you believe now?
Well, yeah, especially, I mean, this is a letter to your lawyer. It's not meant to go anywhere unless it's used.
Well, I think, again, you can dig down this rabbit hole for years. And for people who are interested, I'd encourage you to do it. Well, anyway, another fascinating discussion.
Yes.
Ryan,
yes.
Appreciate it. Appreciate your insights. Look forward to another one.
Yep.